So, hello everyone. Welcome to our first Legal Tech Talks. My name is Ricardo Campos. I'm a lecturer at the Goethe University in Frankfurt and head of international operations at Opice Blum, the biggest law firm dedicated exclusively to digital law in Brazil. Now, that's our first episode of Legal Tech Talk. Just to talk about a little bit about Legal Tech Talk, our ideas is to build a bridge between Brazil and Europe, USA, Asia, and in Africa. So we are now beginning building bridges, and it's a great honor for us to have Trevor here, the CEO and president of the International Association of Privacy Professionals, the world's largest comprehensive global information privacy community in the world. So Trevor, it's a pleasure to have you here. And we'd like to begin, Trevor, with a kind more personal question about privacy. Maybe not all of our audience knows about it, but we would like to know why did you begin thinking about privacy, and why did you begin building? Now, maybe at the beginning, you couldn't say that would become the largest association on privacy. But at the beginning, why privacy? Why not tax law? Why not other fields of legal profession?
Sure. Well, hello, Ricardo. It's great to be here with all of you. I'm delighted to have the chance to chat. And why privacy? What a great question. I graduated from law school in 1995, and I started work at a large insurance company in the United States. I'm Canadian, but I had gone to law school in the United States, and I started work at a large insurance company. And as I started work there, the insurance company was putting up its first website. This was 1995. They had realized that they had to acquire a domain name. So I actually was involved with the legal work on the domain registration. Someone was actually using the name of this insurance company, and we had to go buy the domain name from them. And that was all brand new work. And the reason I got that work was because no one had the internet at home, and we didn't have the internet on our desks. And I happened to have the internet at home. I was using the internet already. And as a result, I got that work. The general counsel, the head of my department looked around and said, well, Trevor, you have some idea about what's going on with this technology, so we're going to let you do the legal work. So even though I was brand new and I didn't know anything yet as a lawyer, I got very, very deep on internet law, on digital signatures, on online contracting, the things that insurance companies were concerned about, and that included online privacy. So my career started really by chance, and the chance occurred because I was interested in technology. My father had worked in the tech industry, and I had grown up with computers around me all the time. And even though I took a political science and a law path, I had a familiarity and a comfort with technology. And from there, I was recruited in 1999, 4 years later, to be a chief privacy officer, to be a leader of a privacy program for a tech company. And I wasn't the first chief privacy officer in the United States, certainly not the first, but I was in the first 40 or 50. And that work was in 1999, 2000. And guess what we were working on? Cookie consent. We were working on cookie consent 20 years ago. And gosh, how sad is that 22 years later, we're still doing the exact same thing. I sometimes wonder if we've solved anything over the past 22 years. And then the dot-com bubble popped, and the IAPP had been formed, but it was being run by a small group of volunteers. And they realized that there was more work than they could handle as volunteers. So they wanted to hire their first executive, their first CEO. And I was a member, and I had spoken at the first conference that the IAPP had run. And so I took that job, and that was 2002, 20 years ago now. And we have grown from that point forward. So yeah, it was a bit of good luck and right place, right time that landed me in the field of privacy.
And it's quite nice how random is our destiny.
Yeah,
and and you just mentioned that you began in 95. And so, as I said, I'm teaching here at the Goethe University, and in Hessen, in my state, was the first data protection law written by a professor from my university.
Wow.
Yes, he's called Spiros Zimitis, a Greek professor.
Yep.
And let's talk about 95. We had the first directive in Europe in 95. Yep. And we had already in Germany since 77, the first federal law on data protection already. In 95, we got the European dimension of data protection. And what would you say, Trevor? So you just talked about cookies. No? Cookies still be the problem today, the big issue today. But at that time, what would you say that at that time were the most important things on privacy? And what would you say today? Now, what would be the frontiers today on privacy?
It's a great question. And I think our thinking about data protection, our thinking about privacy has evolved and matured over the past 25 years. When I look back to 1995, even to 2000, 2001, the prevailing theme was one of control. That the data subject, the individual, the customer, the citizen, that they deserved control. And much of the architecture in policy, much of the policy initiatives of those times, including the 1995 directive, including things like the Children's Online Privacy Protection Act in the US, PIPEDA in Canada, the various laws in Australia, New Zealand, and other places, those laws that had emerged in that era, so many of them focused on the idea of control. And much of the dialogue was about the level of control necessary for any piece of data, any use of data, any processing activities that may occur. We didn't have inside organizations at that time the structures necessary to even implement that control. And so what we had was a policy discussion that was operating and putting forward ideas and creating compliance obligations that organizations simply did not have the IT infrastructure to respond to. And that created a real tension. It also occurred that the pace of technological innovation was so great that the 95 directive, which, let's be clear, it was implemented. It's the 1995 directive. It was written in the 2 or 3 years prior to 1995, which is to say the 1995 directive in Europe never had a full understanding in the heads of the policymakers who held the pen, never had a full understanding of what the broad internet was to become, and certainly could not predict smartphones and the Internet of Things and facial recognition and all of the other technological innovation. I think what we have seen as we progress forward to today, I think what we have seen is that the idea of control has faded a bit. It still has a place in our policy discussions, but the idea of stewardship, of appropriate and legitimate processing, the idea of data processors and controllers having an obligation to serve the interests of the data subject, I feel like that idea has taken hold. It certainly exists within GDPR, but some would even criticize GDPR as being too prescriptive in this regard. I think what we are seeing is a migration towards a recognition that the data in the digital economy today is so complex and so sophisticated. It moves in so many ways, and one visit to one website can generate so many data relationships that any single data subject cannot be asked to understand their entire digital footprint in the world. Rather, those organizations that hold data on their behalf, that process data on their behalf, they are now being given an obligation to handle that data appropriately and within the boundaries of the expectations and the interests of the data subject themselves. That migration, I think, has been massive. The other massive migration that is consistent with that, that move towards accountability and stewardship, is that organizations have invested now in having better digital architectures so as to manage and implement greater levels of data protection and control over these things, so that in those places where we do want control over our data, I think we are far better suited to have it now.
Nice, thank you, Trevor. Interesting. And let's talk about so the US tradition and the European tradition. So as I said, I'm Brazilian, and in Brazil, we are in some ways between US and Europe. In data protection, we are much more closer to the European Union, because we have now we have a federal law on data protection. And let's talk a little bit about US. Now, what do you think about the American tradition on data protection? Is it better to have a federal law? Will the US have a federal law? Is it possible, or it's just a kind of, as we say in German, a kind of music of the future?
I'm going to have to learn that phrase in German. I like it. Let me respond in a number of ways to this. So first of all, as I've traveled around the world, one of the things that I've recognized is that the cultural value of privacy is normative. And what I mean by that is that privacy as a social truth, as a human truth, is born from the cultural expectations and normative values of the society from which it emerges. As a result, privacy is different for a Brazilian than it is for a German. Privacy is different for someone living in India than it is for someone living in Australia. Privacy is different for someone living in the United States than it is for someone living in Japan. It is simply a fact. And I actually find it fascinating and interesting that just like art and food and clothing and culture, privacy differs all around the world. And rather than seeing that as a problem, I think we should celebrate that as a reality of humanity, that we have different understandings and approaches to privacy all around the world. It is simply a fact. So if we agree that privacy differs all around the world in the cultural value placed on privacy, and we can see this in various ways in the US, that with the harms-based approach, the idea that if there is a harm, it should be remedied in the law, and that's what the policy of privacy should focus on. In China, it is about communitarian and social interest, social harmony, and the harmonious flow of societal interactions. That's what they focus on in privacy. In European traditions, it is significantly about ideas of dignity and ideas about individual control and rights over one's data. These ideas differ all around the world. As a result, laws differ all around the world. And you're absolutely right to highlight the fact that Brazil, with the LGPD, has picked up much of the GDPR, but it has added Brazilian aspects, and it lives within a Brazilian legal and political structure. As a result, it has distinctly Brazilian flavors to it. There is a lot of Brazil in the LGPD, which one would expect. When we look at the United States, I think we have to recognize that the United States is, of course, a very large and very unique country. It has 50 states, all of which have individual powers and abilities which are granted under the US Constitution. It has a political structure which is not really set up for broad implementations of major law right now. The tension in US political structure is real. The debate between and the conflict between the political parties is significant, which results in there being a lot of friction in the passage of legislation. With all of that said, let's take a snapshot of the United States. In the United States, the approach to privacy, the legal history of privacy, of course, goes back to 1890 with Brandeis and Warren writing The Right to Privacy, just an hour from where I'm sitting right now. But it also traces back to the 1970s, actually the early 1970s, with some of the earliest formulations of the Fair Information Practices. And in 1973, I believe it was, the US Privacy Act. Now, that was about the government's use of data with regards to citizens, but it was a privacy law. So there is a deep history of privacy in the United States. One of the foundational documents in the history of privacy, The Right to Privacy, was written in Boston, Massachusetts. Alan Weston's book in 1967, Privacy and Freedom, which introduced the idea of informational privacy to the world, written in New York City at Columbia Law School. So there is a deep history in the United States of privacy, and it is wrong to say that the US does not have privacy law. In fact, it has too many. It has too many privacy laws. There are a few hundred privacy laws in the United States, and that number keeps increasing as states keep passing broad-based comprehensive privacy law. As we see that global environment move towards data protection standards around the world, as we see the US market increase in complexity, I think it's reasonable to expect that we will see US national privacy legislation in the next 3 to 5 years. We are predicting it and preparing for it at the IAPP. I will tell you that 3 months ago, if you asked me to give a percentage chance that we'll see a US law this year, I would have said less than 20%. In the past 2 weeks, we've seen activity in the Senate. And I actually think that that chance has increased. It may still be below 50%, but it might be 40, 45% chance. There is momentum. The case leaked from the Supreme Court, the Dobbs case, which is a constitutional right to privacy case, which relates back to abortion and the Roe v. Wade decision, that actually is a provocation for national privacy law in the United States as well. So all of these things add up to, there is a global framework of data protection laws. They differ because communities, cultures, legal histories, normative values differ. The US absolutely has a long and deep history when it comes to privacy, but it absolutely is it has been slow to move towards national privacy legislation, but I think that we will see national privacy legislation in the coming 3 to 5 years in the United States.
Thank you, Trevor. Just to make one point on it. It's interesting to see, as you said, that in US, you have already privacy tradition, not only at on the level of the academics and so on, but also in the fields of legislation and regulation. But just to make one more point on that, if your prediction is correct, so in 2 years, what would change in the American landscape of privacy if in 2 years we we have federal legislation? What would change for the landscape of privacy?
Yeah, it's a very good question. And I think there is a dialogue, there is a debate in the United States right now that national privacy legislation may not improve privacy in the United States, that the states have more ability to be aggressive, be progressive in the passage of privacy legislation. And let's be clear, when California passes a law, it becomes a de facto national standard. Everyone in the United States that deals with privacy law has paid attention to the CCPA and the CPRA in California. And there is a fear that a national law for privacy would not actually increase the level of privacy and data protection in the United States, but it would negotiate down the more progressive standards that have already been seen in U.S. state law. There are other arguments that would suggest that the more state law we see, the more transgressions in the marketplace we see of privacy, the more concern that gets raised by citizens, by consumers, by people in the US marketplace, the more likely it is that we see something quite significant. I would say that the staff members who are working on these bills that we have talked to, that I have talked to, they are very much aware of the GDPR. They are very much aware of California law. They are very much aware of the fact that a US law that passes, that is a most basic standard style law, is not going to be received very well in the global community. And given that most US multinationals have already addressed GDPR, they'll shrug their shoulders and it won't be that significant a legislative moment. And so there is an awareness of that. And I would not be surprised to see some of the ideas that I've described of stewardship, of accountability, of less reliance on control and consent and notification, less reliance on those. They still have a place, but less reliance on those policy tools and more on placing obligations on organizations for fair processing, operating in the interests of the data subject, operating in a way that is accountable and understandable and repeatable. I would expect those types of ideas to emerge even more strongly.
Interesting. Let's go to our last question, Trevor. It's not only a trend topic on data protection, but also something very, very, very crucial. It's maybe the heart of the internet. It's data transfer. Without data transfer, we couldn't talk today, for example. We couldn't talk today being in Frankfurt, in Boston, and with a Zoom account from Brazil. It's quite impressive how it works today. And data transfer has been a big issue today in data protection. And it's quite interesting to see how this team emerged in the last time. It was also through litigation, through cooperation, and again litigation, and now again cooperation. So let's talk a little bit about the European and American cooperation on data transfer. What do you see that they could handle with this cooperation, and what would be the impact on data protection?
Yeah, so of course it's a very good, but also a massive question. Let's start with the source of much of the concern and complexity here, and that is the GDPR. The GDPR, with restrictions on data transfers out of Europe, creates a series of obligations on organizations that are challenging. We should note that there are very, very, very few countries in the world that have been recognized as adequate. by the European Union. And as a result, there are very few places in the world that you can transfer data from Europe without having some other mechanism to demonstrate the appropriate protections on that transfer. We also have to highlight the fact that Europe and the United States, certainly at a political level, have long recognized the incredible importance and the enormous amount of trade and connection culturally, socially, economically that transfers between the two countries. And as a result, going back to the safe harbor and then to the privacy shield, we have seen treaties that actually try to protect the free flow of information between those massive jurisdictions. Of course, the black letter of the law, the actual words of the law, and the interpretation of independent courts and the provocation of advocates like Max Schrems and others really tests the nature of those treaties, the nature of those data transfers against what the law actually says. I would also note that the complexity of the situation that we have landed in globally with regards to data transfers is not beneficial. Now, I want to make really clear, the IAPP is not a policy organization, so I'm not making a position statement on behalf of the IAPP here. This is, if anything, a very personal reflection on this. But as I look at the number of contracts, the nature of transfer impact assessments, the work that has to be done in order to create a legal architecture through which you can have some degree of assurance that you are complying with the GDPR, it is inconsistent with the level of protection that's actually being afforded and inconsistent with the amount of risk that actually is occurring to data. That those things do not quite match up. And I think that imbalance suggests that our work is not done. We can't have data transfers continue to get more and more and more complex because, as you rightly pointed out, I'm a Canadian working in the United States, talking to a Brazilian sitting in Germany on a Zoom platform coming out of Brazil. And it is a global digital economy. Data flows all over the world at increasingly rapid speeds. If we allow this digital economy to become splintered and protectionism and isolationism and digital barriers to really emerge around the free flow of data, I do worry that we would be doing a number of things that we may not be happy with. The level of services would certainly drop. Our ability to communicate with each other would certainly drop. The ability for developing economies and markets that do not have broad-based tech footprints, I think the ability for them to compete in the digital economy would also suffer as well. And so maybe this is a great closing point. All of this points back to professionals. It points back to the people who do this work, that our work is incredibly important. Yes, we protect data, but we also are the guardians of trust of the digital economy. And it is incumbent on us. It's our job to help create trust in the digital economy. And whether that is through data transfers, whether that is through accountability or stewardship, that's an incredibly big job. And I think we have lots and lots of work ahead of us.
Thank you, Trevor. Just a last point on our conversation. I often say at the university here in Frankfurt, Trevor, that there is no university in the world with the importance and impact of building privacy as the IAPP. So congrats for your job. I've been in DC last month on the conference, and I was impressed by the quality and also how big is the conference and how comprehensive so is the association. So thank you, Trevor, for being with us, and see you.
Muito obrigado. Thank you, Ricardo.
De nada, grande abraço.